Elena Martinez had never asked for much. All she wanted was to live like anyone else, safely, with dignity, and without having to beg for basic access. She was 38 years old, lived alone in a modest one-bedroom apartment on the second floor of a building that had seen better days, and worked from home as a freelance graphic designer. Her days were quiet but full, sketching logos, editing photos for small businesses, and sometimes helping local nonprofits with their websites. She liked the rhythm of it, the hum of her laptop, the soft tap of her stylus on the tablet, the way sunlight filtered through her window in the late afternoon. But there was one thing that kept stealing that peace: the front steps of her building. They were steep, narrow, and had no handrail. For most people, they were just stairs. For Elena, who used a wheelchair due to cerebral palsy, they were a wall, a barrier, a daily reminder that the world wasn't built for people like her. She hadn't always used a wheelchair. As a child, she'd walked with braces and a walker, but over time her muscles weakened, and by her late 20s, a manual wheelchair became her most reliable way to get around. She'd adapted, learned to navigate sidewalks with cracked pavement, buses that sometimes forgot to lower their ramps, and stores with entrances too narrow for her chair. But home was supposed to be different. Home was supposed to be safe. When she first moved into the apartment 2 years ago, the landlord, a man in his 50s with a permanent scowl and a habit of avoiding eye contact, had assured her the building was ADA compliant. She'd asked specifically about accessibility. He'd waved a hand and said, "Oh yeah, sure, we've got everything covered." She should have asked for proof, but she was tired from the move, hopeful, and honestly, she just wanted a place to rest. It didn't take long for the truth to surface. The front entrance had 3 concrete steps. No ramp, no lift, nothing. The only other way in was through a side alley that led to a back door, but that door was often locked, the path uneven and littered with broken glass, and during rain it turned into a muddy trench. More than once she'd been stranded outside, waiting for a neighbor to notice and help her in. Once, during a thunderstorm, she'd sat in her chair under a dripping awning for over an hour, soaked and shivering, because no one heard her knocks. She started asking for a ramp. At first, politely. Then firmly. Then desperately she sent emails, left voicemails, wrote letters. Each time the landlord gave a new excuse. "We're looking into it. The contractor's backed up. It's not in the budget right now. Honestly, you're the only one who's ever complained." The last one stung the most, not because it was rude, but because it was true. She was the only one, and that made her feel invisible. What made it worse was how she had to communicate. Cerebral palsy affected her speech, making it slow and sometimes hard to understand for people who weren't used to it. She used a speech-generating device, a tablet mounted on her wheelchair that spoke for her when she typed. It worked well, but not everyone had the patience to wait while she spelled out a sentence. Some people talked over her. Others pretended not to hear. The landlord? He'd sigh loudly, glance at his watch, and say, "Can't you just figure something out?" She tried. She really did. She looked into portable ramps, but the ones that could handle her building's step height cost over $800, money she didn't have after paying rent and medical bills. She asked neighbors if they'd help push her chair up the steps, but it was dangerous, and she hated putting anyone at risk. One time, a kind teenager tried and nearly dropped her. She wasn't hurt, but the fear in his eyes afterward haunted her. Then came the job interviews. She'd been applying for a full-time remote design position with a growing tech startup. They loved her portfolio. They scheduled 2 video interviews, but on the day of the second one, she couldn't leave her apartment. The side alley was blocked by a delivery truck and the front steps were impossible. She missed the call. When she explained what happened, the hiring manager was sympathetic, but said they'd moved forward with another candidate. "Timing is everything," they wrote. That was the breaking point. She sat in her living room that night staring at her screen, tears blurring the words of yet another rejection email. Not because she wasn't good enough, but because she couldn't get out her own front door. The next morning, she made a decision. She wasn't going to beg anymore. She was going to fight. She spent days researching her rights. She learned about the Americans with Disabilities Act, specifically Title III, which requires public accommodations, including rental housing, to remove barriers when it's readily achievable. She found city records showing her building had received complaints before. She even tracked down a letter from the local housing authority, sent a year earlier, warning the landlord about ADA violations. He'd ignored it. Armed with printouts, screenshots, and a growing folder of evidence, she filed a formal complaint with the city's civil rights office. They responded quickly. Her case was valid, but enforcement could take months or years. They suggested she consider legal action. That's when reality hit her again. Lawyers were expensive. Legal aid services in her area had a 6-month waiting list. She called 3 different disability rights organizations. All were overwhelmed. One volunteer told her gently, "You have a strong case. But without a lawyer, it's an uphill battle." She almost gave up, but then she remembered the job interview. The rain, the locked door, the feeling of being trapped in her own home. No, she wouldn't let this go. She decided to represent herself. It wasn't pride. It was necessity. She read everything she could find about small claims court procedures, how to present evidence, how to address a judge. She practiced typing responses on her device faster. She recorded herself giving a statement and played it back, adjusting her tone, her pacing. She even visited the courthouse website to check accessibility, only to find that the main entrance had steps too. No mention of a ramp, no elevator, nothing. She called the clerk's office. "Do you have an accessible entrance?" she asked, her device speaking in its calm, synthetic voice. There was a pause. I think there's a side door, but I'm not sure. Can someone meet me at the curb if I need help getting in?" Another pause. I don't know who would do that." She hung up, heart sinking. But she didn't cancel. She just planned ahead. On the morning of her court date, she woke before dawn. She charged her device, packed her evidence in a waterproof folder, and laid out her best blouse, the one that made her feel confident, not fragile. She called a rideshare service that offered wheelchair-accessible vehicles, but none were available. So she booked a regular one and hoped the driver would help her lift her chair into the trunk. He did, grumbling the whole time. When she arrived at the courthouse, her stomach dropped. 3 wide stone steps led to massive double doors. No ramp, no signage, no help in sight. She sat there for a moment, gripping her wheels, trying not to cry in front of strangers. Then she spotted a man in a janitor's uniform coming out a side door with a trash bag. "Excuse me," she typed. Her device spoke clearly. "I have a hearing inside. Is there an accessible entrance?" The man blinked, then looked at the steps, then back at her. "Oh, no, not really. But I can help you up if you want." It wasn't ideal. It wasn't dignified. But it was her only option. With his help, and the awkward assistance of a passing security guard, she made it inside, her chair scraping against the stone, her cheeks burning with embarrassment. Inside, the hallway was cold and echoing. People hurried past, eyes forward, as if she were part of the furniture. She found the courtroom number and wheeled herself in. It was small, with hard wooden benches and fluorescent lights that buzzed overhead. A few people were already seated, mostly landlords and tenants in similar disputes. She recognized her landlord immediately. He sat near the front, arms crossed, scrolling on his phone, looking bored. He didn't look at her. She took a seat near the back, opened her folder, and reviewed her notes one last time. Her hands trembled slightly, but she took a deep breath. She reminded herself this wasn't just about a ramp. It was about being seen, being treated like a person who mattered. A bailiff called the docket. Her case was third. When her name was called, she rolled forward slowly. The judge, a man in his 60s with thinning gray hair and a sharp nose, looked up from his papers. His eyes flicked to her chair, then to her device, then back to his notes. He didn't smile. "Ms. Martinez?" he asked, voice flat. She nodded and began typing. The device spoke. "Yes, Your Honor." The landlord's lawyer stood. He was young, polished, wearing a suit that probably cost more than her monthly rent. He gave a quick, dismissive glance in her direction before addressing the judge. "Your Honor, this case is a waste of the court's time. My client has made reasonable efforts." Elena's heart pounded. She hadn't even started, but she stayed calm. She had her evidence. She had the law. And she had something the landlord and his lawyer didn't. The truth. She just needed a chance to tell it. And as she sat there, waiting for the judge to let her speak, she realized something important. She wasn't scared anymore. She was ready. Because sometimes the most powerful voice isn't the loudest, it's the one that refuses to be silenced, even when the world tries to talk over it. The courtroom felt colder than it should have. Not just from the air conditioning humming overhead, but from the way people looked at her, like she didn't belong, like she was a mistake that wandered in by accident. She sat near the front now, her wheelchair positioned carefully so she could face the judge without straining her neck. Her hands rested on the armrests, steady on the outside, but inside, her pulse tapped like a nervous drum against her ribs. The judge, tall, with tired eyes and a voice that sounded like he'd rather be anywhere else, leaned back in his chair. He glanced at the landlord's lawyer, then at her, then down at the file in front of him. He sighed just barely, but she heard it. It was the kind of sigh people make when they've already decided how something will end. "All right," he said, tapping his pen. "Let's get this over with. Plaintiff, you're representing yourself?" Her device spoke for her, clear and calm. "Yes, Your Honor." He nodded once, not unkindly, but without warmth. "Proceed with your opening statement." She took a breath. She'd practiced this a dozen times in her apartment, standing in front of her mirror, typing the words slowly, listening to how they sounded. She wanted to sound confident, not angry, factual, not emotional, but now, under the bright lights and the weight of silence, it felt different. She began typing. Each word appeared on her screen, then her device voiced it aloud. "Your Honor, I live in a 2-story apartment building. There is no ramp at the front entrance. I use a wheelchair. For over a year, I have asked my landlord to install a ramp so I can enter and exit my home safely. He has refused." She paused, waiting for the words to settle. The judge scribbled something. The landlord's lawyer shifted in his seat, arms crossed, one eyebrow slightly raised. She continued, "Because of this, I've been stranded outside my apartment multiple times. I've missed job interviews. I've had to crawl through a side alley during rainstorms. I've asked for help from city officials. They confirmed the building violates the Americans with Disabilities Act." The lawyer stood abruptly. "Objection, Your Honor. The plaintiff is making unsubstantiated claims and quoting laws she doesn't fully understand." The judge raised a hand. "Overruled. She's allowed to state her case." "Continue, Ms. Martinez." She nodded and kept going, her fingers moving faster now. She described the emails she'd sent, 12 of them. The voicemails she'd left, 8, all unanswered. The letter from the city's housing compliance officer, dated 6 months ago, stating clearly that a ramp was readily achievable and required by law. She held up printed copies, passed them to the bailiff, who handed them to the judge. But something strange was happening. Every time her device spoke, the judge would glance at it, then at her, then back at his papers. His expression wasn't angry, but impatient, like he was waiting for her to finish so he could move on to a real case. Once, when she took a few extra seconds to type a longer sentence, he tapped his pen twice on the desk and muttered, "Come on, let's keep it moving." The lawyer smirked. He leaned toward his client and whispered something. The landlord chuckled softly, just loud enough for her to hear. Heat rose in her chest, not from shame, but from frustration. She wasn't some nuisance. She wasn't exaggerating. Every word she said was true, backed by proof. And yet they treated her like she was wasting their time. She pressed on. She played a voicemail she'd saved, one where she'd called the landlord after slipping in the alley and scraping her arm. Her voice on the recording was shaky, strained, but clear. "I can't get into my apartment. The side door is locked again. Please just send someone to unlock it or let me know when the ramp will be installed." The recording ended. Silence followed. Then the lawyer stood again. "Your Honor, this is highly irregular. Playing personal recordings? This isn't a courtroom drama. And frankly, the plaintiff's communication method makes this entire proceeding inefficient." She's slowing down the docket. The judge looked at her, then at the lawyer. "She's within her rights to present evidence," he said, but his tone lacked conviction. He turned back to her. "Ms. Martinez, I understand you're trying your best, but perhaps you should consider getting legal representation." "These matters are complex," she typed quickly, her device responding almost instantly. "I can't afford a lawyer. Legal aid has a 6-month wait list. I have a right to represent myself." The judge exhaled through his nose. "Of course you do. But the court has many cases today." "Try to be concise," she nodded, but inside something tightened. They weren't just doubting her case, they were doubting her ability, her intelligence, her right to be here at all. What they didn't know was that she'd spent nights studying court procedures, reading ADA guidelines, watching videos of real hearings. She knew more about accessibility law than most people in that room, but none of that mattered if they wouldn't listen. She moved to her next piece of evidence: photos. She'd taken them herself over several months. Images of the 3 steep steps, the broken pavement in the alley, the locked back door with rusted hinges. One photo showed her wheelchair tipped sideways after she'd tried to navigate a puddle and lost balance. Another showed her sitting in the rain, soaked, waiting. She held up the printed photos one by one. The bailiff passed them to the judge. He glanced at them, then set them aside without comment. The lawyer stood again. "Your Honor, these are just photos. They prove nothing. Anyone can take pictures and claim hardship. My client has tenants who manage just fine. If the plaintiff chose a building without full accessibility, that's on her." That did it. She typed fast, her fingers almost flying. "I asked about accessibility before I moved in. The landlord told me the building was ADA compliant. That was a lie. And the law doesn't say only if it's convenient. It says barriers must be removed when it's readily achievable. A ramp costs under $2,000. My landlord owns 5 buildings. He can afford it," the lawyer scoffed. "$2,000? That's your estimate? You're not a contractor. You're not an architect. You're a graphic designer. With respect, Your Honor, this is emotional pleading, not legal argument." The judge rubbed his temple. "Ms. Martinez, I appreciate your effort, but you're mixing personal frustration with legal standards. The court can't order someone to spend money just because it would make life easier for a tenant." She froze. That wasn't true. The ADA did require it. She had the statute right in her folder. But before she could respond, the judge turned to the lawyer. "Do you have anything further?" "Yes, Your Honor." The lawyer straightened his tie. "We ask the court to dismiss this case with prejudice. The plaintiff has failed to demonstrate any legal violation, and her self-representation has only delayed a straightforward matter." The judge nodded slowly. "Very well. Ms. Martinez, unless you have something new to present, something concrete, I'm inclined to agree." Her heart sank. This was it. They were going to throw her case out. Not because she was wrong, but because she didn't look or sound like what they expected a real plaintiff to be. But then she remembered something. Tucked in the back of her folder was a letter she hadn't planned to use yet. It was from the city's ADA compliance officer, a woman who'd visited her building after her 3rd complaint. The letter stated clearly, "Failure to provide an accessible entrance constitutes a violation of Title III of the Americans with Disabilities Act. Installation of a ramp is readily achievable and must be completed within 30 days." She pulled it out, her hands shook, but she held it up. "Your Honor, I have an official letter from the city confirming the violation." The judge hesitated. "Let me see that." The bailiff took it. The judge read it slowly. His expression changed just slightly. His eyebrows lifted. He turned the page over as if expecting a trick. The lawyer leaned forward, suddenly less confident. "Your Honor, city letters aren't binding in civil court. They're advisory at best." "Maybe," the judge said, still reading. "But it's hard to ignore." He set the letter down, looked at her, really looked at her for the first time. "You've been trying to get this fixed for over a year?" he asked. "Yes," her device replied. "And you've documented every step?" "Yes." He leaned back, steepling his fingers. The courtroom felt quieter now. Even the lawyer seemed to hold his breath. Then the judge did something unexpected. He turned to the landlord. "Did you receive this letter from the city?" The landlord shifted. I might have. I get a lot of mail. You might have?" The judge repeated, voice sharper now. "This is a formal compliance notice. Ignoring it isn't just rude, it's reckless." The landlord mumbled something under his breath. The judge turned back to her. "Ms. Martinez, I apologize if I seemed dismissive earlier. This is more serious than I first assumed." She didn't smile. She didn't gloat. She just nodded. Because she knew this wasn't over. The judge might be listening now, but the real test was coming. Cross-examination. And the landlord's lawyer wasn't going to go down without a fight. As the judge announced they'd take a 10-minute recess, she rolled back slightly, her shoulders tight with tension. People began whispering. A woman in the back row gave her a small, encouraging nod. The janitor from earlier peeked in through the doorway, then quickly stepped away. She closed her eyes for a moment. She hadn't come here for sympathy. She hadn't come for applause. She'd come because she deserved to roll through her own front door without fear. And she wasn't leaving until that truth was heard. Even if it took every ounce of patience she had, even if they kept underestimating her. Because sometimes, the quietest voices carry the heaviest truths, and the world only hears them when it's forced to stop and listen. The 10-minute recess felt like both an eternity and no time at all. She sat in the hallway just outside the courtroom, her back against the cool cinder block wall, eyes closed, breathing slowly. Her fingers rested on her device, ready, but her mind was racing. She replayed every word she'd said, every glance from the judge, every smirk from the landlord's lawyer. Had she been clear enough? Had she sounded too angry? Too desperate? Too different? A woman in a courthouse uniform, maybe a clerk, maybe a bailiff, walked by and paused. "You doing okay?" she asked quietly. She opened her eyes and nodded. Her device spoke softly. "Just getting ready." The woman gave a small smile. "You're doing better than most with lawyers." It was a tiny thing, but it warmed her. She wasn't alone. Not completely. When they called the court back into session, she rolled in slowly, her chair making that familiar soft whir on the linoleum floor. The judge was already seated, his expression unreadable. The landlord looked nervous now, fidgeting with his watch. His lawyer had lost some of his swagger. He sat straighter, papers neatly stacked, eyes sharp. "All right," the judge said. "We'll continue with the plaintiff's presentation. Ms. Martinez, you may proceed." She took a breath and began this time. She didn't just present facts, she told a story. Not with drama, not with tears, but with quiet clarity. She explained how on a Tuesday morning last March, she'd woken up to an email from a design firm offering her a video interview for a full-time remote job. It was the kind of opportunity she'd been working toward for years. Stable pay, health insurance, creative freedom. She'd prepared for days, cleaned her background, tested her camera, rehearsed her answers. But the night before, her device said, "A delivery truck blocked the only accessible path to my building, the side alley. The front steps were impossible. I called my landlord at 7 a.m. He didn't answer. I called again at 8, still nothing. The interview was at 9, she paused. The courtroom was silent. I sat outside my building for 2 hours. Rain started falling. My laptop got wet. I missed the interview. When I emailed to explain, they said they'd moved on. They needed someone reliable." She let that hang in the air. Then she added, "Reliable doesn't mean perfect. It means having a way to leave your home." The judge's pen stopped moving. He looked up, she moved on. She showed a photo of the alley after a storm. Puddles deep enough to submerge her wheels, broken glass glinting in the mud. "I've fallen twice trying to get through there," she said. "Once I cut my hand badly. I had to crawl to my door and bang on it until a neighbor heard me." She didn't say it for pity. She said it because it was true. And truth, she'd learned, was the only weapon she had. Then came her next move, one she'd saved for this exact moment. She pulled out a USB drive and handed it to the bailiff. "Your Honor, I'd like to play a short audio recording from a city ADA inspector who visited my building last fall." The judge raised an eyebrow but nodded. The bailiff plugged the drive into a small speaker at the clerk's desk. A calm, professional voice filled the room. "On October 12th, I conducted an accessibility review of 417 Oak Ridge Lane. The main entrance consists of 3 unmarked concrete steps with no handrail, no ramp, and no alternative accessible route. This constitutes a clear violation of 28 CFR paragraph 36.211, which requires public accommodations to maintain accessible features. Installation of a permanent ramp is readily achievable and should be completed without delay." The recording ended. The lawyer stood immediately. "Your Honor, hearsay. That's not live testimony. We can't cross-examine a recording." "It's an official city document," she typed quickly. "It's part of the public record. I can provide the case number." The judge held up a hand. "It's admissible as a public record." "Sit down, counselor." The lawyer sat, jaw tight. She wasn't done. Next, she played a second recording, this one from her own phone. It was a voicemail she'd saved from the landlord, left after her 5th request for a ramp. His voice was impatient, dismissive. "Look, I don't have the money right now. And honestly, you're the only one who's ever had a problem with the stairs. Maybe you should have thought about that before you moved in." The courtroom seemed to shrink. Even the air felt heavier. The judge's face darkened. He turned to the landlord. Is that your voice? The man shifted. I don't remember saying that. You don't remember telling a disabled tenant she should have thought about her disability before renting from you? The judge asked, voice low. The landlord mumbled. I was frustrated. She kept calling. Frustrated? The judge repeated. Because someone asked for a legal accommodation? That's not frustration. That's negligence. For the first time, the lawyer looked worried. He whispered something to his client, but the landlord just shook his head, eyes down. She watched it all unfold, her heart steady now. She wasn't just defending herself anymore. She was holding up a mirror, and what they saw in it wasn't pretty. Then she did something unexpected. She queued up a third audio file, but this one wasn't hers. This is a statement from a disability rights attorney with the state protection and advocacy agency, she explained. She reviewed my case and confirmed the landlord's actions violate federal law. The voice that played was calm, authoritative. Under the ADA, housing providers must make reasonable modifications when requested by a person with a disability, especially when those modifications are readily achievable. Denying access to a primary entrance based on cost or inconvenience is unlawful. The tenant in this case has more than met her burden of proof. When it ended, the judge sat back slowly. He looked at her, then at the stack of evidence on his desk. Emails, photos, letters, recordings. He flipped through them again, slower this time. You've been very thorough, Ms. Martinez, he said. And for the first time, his voice held something like respect. She nodded. I had to be. Now it was the landlord's turn to present his side. His lawyer stood, cleared his throat, and tried to regain control. Your Honor, my client is a small property owner. He's not a corporation. He's done his best with limited resources. The plaintiff is asking for a structural modification that could cost thousands. The law doesn't require financial ruin for the sake of convenience, she almost laughed. Convenience. As if being able to leave your home was a luxury. But she stayed quiet. Let him talk. He called the landlord to the stand. Under oath, the man admitted he'd received the city's letter.
He admitted he'd ignored it.
He admitted he'd never looked into the actual cost of a ramp. I just assumed it was expensive. When asked if he'd ever offered any temporary solution, like a portable ramp or assistance, he said, I figured she'd figure something out. The judge's eyes narrowed. You figured she'd figure something out? While she was stranded in the rain? While she was missing job interviews? Is that your standard of care for tenants? The landlord had no answer. Then came the moment she'd been waiting for. The lawyer turned to her. Cross-examination. She straightened in her chair. This was where most self-represented people faltered, where lawyers used complex questions to confuse, trap, or fluster. But she'd prepared for this too. The lawyer started gently, almost kindly. Ms. Martinez, you're a graphic designer, correct? Yes. And you work from home? Yes. So you don't actually need to leave your apartment very often, do you? She typed fast. I need to leave for groceries, doctor appointments, job interviews, emergencies, and basic human dignity. He smiled thinly. But you manage, don't you? You have neighbors who help. You've gotten by for 2 years. Getting by isn't the same as living, her device replied. A few people in the gallery shifted. Someone murmured, That's true, the lawyer pressed on. Isn't it possible you're exaggerating the difficulty? After all, many people with disabilities live in older buildings without ramps. Many people also suffer in silence, she said. That doesn't make it right. He tried another angle. You chose this apartment. You signed the lease. Didn't you inspect it before moving in? I asked if it was accessible. I was told it was, and you believed him? I had no reason not to. But you have a speech device, he said, gesturing to her tablet. You're clearly intelligent. Shouldn't you have verified that claim? She didn't flinch. Trusting someone isn't a crime. Lying is. The courtroom went still. The judge cleared his throat. Counsel, that's enough, but the lawyer wasn't done. He leaned forward, voice dropping to a near whisper, as if sharing a secret with the judge. Your Honor, with all due respect, is it really fair to hold a small landlord to the same standard as a hotel or a mall? This isn't a public business. It's a home. The judge looked at her, then at the law on his desk, then back at the lawyer. Actually, he said slowly, under Title III of the ADA, residential rental offices and common areas are considered places of public accommodation. And the front entrance? That's a common area, so yes. The same standard applies. The lawyer's face fell. She almost felt sorry for him. Almost, she knew then. She'd won. Not because the judge said so, but because the truth had finally cut through the noise. They couldn't pretend anymore. They couldn't hide behind inconvenience or budget or she's the only one. The evidence was too clear. The law was too clear, but she didn't celebrate. Not yet. Because winning in court wasn't just about a verdict. It was about setting a precedent. About showing every other person who'd been told no, not now, or figure it out yourself, that they had a right to be heard. Even without a lawyer. Even with a voice that didn't sound like everyone else's. As the lawyer sat down, defeated, she looked out at the small crowd in the gallery. A young woman in a wheelchair gave her a thumbs up. An older man nodded slowly, like he'd seen this kind of thing before, and was glad to see it end differently this time. The judge shuffled his papers. Ms. Martinez, do you have anything else to add before I consider my ruling? She thought for a moment. Then she typed one last sentence. Her device spoke clearly, calmly, and with quiet strength. I just want to go home through the front door. No one said a word, and in that silence, louder than any argument, the truth echoed through the room like a bell. The silence after her last words stretched like a held breath. No one moved. No one whispered. Even the hum of the fluorescent light seemed to quiet down, as if the whole room understood something important had just been said. Not with anger, not with demands, but with simple, unshakable truth. She just wanted to go home through the front door. Was that really too much to ask? The judge looked down at his desk, fingers tapping once, twice, then stopping. He wasn't writing. He wasn't flipping pages. He was thinking. And for the first time since she'd rolled into that courtroom, she felt something shift in the air. It wasn't pity. It wasn't charity. It was recognition. Like he finally saw her not as a problem to be managed, but as a person who'd been wronged. He cleared his throat. Counsel, he said, turning to the landlord's lawyer, do you have anything further in your defense? The lawyer stood, but slower this time. His shoulders weren't as square. His voice lacked its earlier sharpness. Your Honor, we stand by our position, but given the evidence presented, we acknowledge the city's letter and the plaintiff's documentation. However, we still maintain that the cost and logistics of installing a ramp present a hardship for my client. Hardship? The judge's voice was calm, but there was steel underneath. Let me be clear. The law doesn't require perfection. It requires reasonable effort. And from what I've seen today, your client made no effort at all. Not one. The lawyer opened his mouth, then closed it. He sat back down. The judge turned to the landlord. You've owned this building for how long? 8 years, the man mumbled. And in all that time, you never once considered accessibility? Not even after the city sent you a formal notice? The landlord shifted in his seat. I guess. I didn't think it was that serious. That's the problem, the judge said, leaning forward slightly. You didn't think. You assumed someone else would deal with it. Or worse, you assumed it didn't matter because it wasn't happening to you. He paused, then looked directly at her. Ms. Martinez, you mentioned lost job opportunities. Can you be more specific about the financial impact? She nodded and pulled out a printed email from the tech startup, the one that had offered her the interview. She also had a note from her doctor about a missed appointment that resulted in a late fee and delayed treatment. She'd even calculated the cost of rideshare services she'd been forced to use when neighbors weren't available. Over $300 in 6 months. I've lost income, her device said. Not just from missed interviews, but from stress-related health issues. I've had to pay extra just to leave my home. The judge took the documents. He read them carefully. Then he turned back to the landlord. You realize that under the ADA you can be held liable not just for the modification itself, but for damages caused by your failure to comply? The landlord's face went pale. I didn't know that. Now you do, the judge said flatly. What happened next surprised even her. The judge didn't rush to a verdict. Instead, he asked a question that changed everything. Ms. Martinez, if the court orders a ramp installed, do you have any preference on design or timing? It was a small thing, but it meant he'd already decided she was right. He wasn't asking if it should happen. He was asking how. She typed quickly. I'd like it to meet ADA standards, minimum 36-inch width, Non-slip surface, handrails, and as soon as possible. Every day without it is a risk, he nodded. Noted. Then he turned to the clerk. Please pull up the city's building code for accessible entrances. Let's confirm the exact specifications. While they waited, the courtroom stayed quiet. The landlord stared at the floor. His lawyer scribbled notes, but they looked more like damage control than strategy. A few people in the back exchanged glances, some surprised, some nodding like they'd seen this coming. She used the moment to breathe. Her hands were steady now. The fear that had coiled in her stomach since morning had loosened. Not because she knew the outcome, but because she'd done everything she could. She'd spoken. She'd shown proof. She'd stayed calm when they mocked her. That was enough. Whatever happened next, she wouldn't regret how she'd handled herself. The clerk handed the judge a printed page. He scanned it, then looked up. According to city code, a permanent ramp for a 3-step entrance like yours is not only required, it's considered a basic low-cost modification. Estimated cost between $1,200 and $1,800 depending on materials. He turned to the landlord. Is that within your means? The man hesitated. I suppose. You suppose? The judge's voice was quiet but sharp. You own 5 rental properties. You filed tax returns showing steady income, and yet you couldn't spare $2,000 to let a tenant enter her own home safely, not even after being warned by the city? The landlord had no answer. He just shook his head. Then the judge did something unexpected. He looked at her and said, Ms. Martinez, would you be open to mediation? We could order the ramp and damages, but perhaps we can avoid a formal judgment if your landlord agrees to full compliance immediately. She thought about it. A formal judgment would stay on his record. It might deter him from doing this to someone else. But mediation meant faster action. No appeals. No delays, she typed. Only if he signs a binding agreement today with a deadline of 14 days and pays for my documented losses. The judge nodded. Reasonable. He turned to the landlord. Do you agree? The man looked at his lawyer, who gave a small, resigned shrug. Yes, the landlord said quietly. I'll do it. But the judge wasn't finished. Before we proceed, he said, I want to make something clear. This isn't just about one ramp. This is about respect, about basic human decency. The law exists because people like you, people in positions of power, have ignored the needs of others for too long. Today you got caught. But I hope you understand, this wasn't a win for her because she's disabled. It was a win because she refused to be ignored. The landlord stared at his shoes, then the judge turned back to her. Ms. Martinez, you handled yourself with remarkable composure. Most people, with or without lawyers, would have lost their temper in your position. You didn't. You stuck to the facts. You stayed calm. That took courage. She didn't know what to say, so she just nodded. But inside something swelled. Not pride exactly, but relief, like a weight she'd carried for over a year had finally cracked open and started to lift. The clerk began drafting the agreement. The landlord signed it with a shaky hand. The judge initialed it, stamped it, and handed her a copy. Ramp installed within 14 days, he said. $12,000 in damages for documented losses and emotional distress. And if he fails to comply, you can return to court and I'll hold him in contempt. She held the paper like it was fragile. It wasn't just paper. It was a promise, a path forward, a front door she could finally use. As they wrapped up, something else happened, something small but powerful. The bailiff, the same one who'd helped carry her chair up the courthouse steps that morning, walked over. Need help getting out? He asked. She smiled and shook her head. I'm okay. But thank you, he nodded. You did good in there. A woman from the gallery approached too. She was older, walked with a cane, and spoke softly. My grandson uses a wheelchair. I've been fighting with his school for months about access. Watching you, it gave me hope. They talked for a few minutes. Just two people sharing a moment of understanding. No grand speeches. No cameras. Just real life. When she finally rolled out of the courtroom, the hallway felt different. Lighter. People made eye contact. Some even moved aside to give her space, not out of pity but out of respect. She passed the janitor again near the side exit. He saw her and grinned. Heard you won, she nodded. Her device said, Thanks for helping me get in this morning. He shrugged. Anytime. Next time maybe they'll fix the steps. She laughed. A real laugh. the kind that bubbles up when tension finally breaks. Outside, the sun was high. The air smelled like rain and city pavement. She called a rideshare, and this time an accessible van arrived within 10 minutes. As she loaded her chair into the back, she looked up at the courthouse steps. The same ones that had humiliated her hours earlier. She wouldn't have to climb them again. And that thought, simple as it was, filled her with a quiet kind of joy. Because justice isn't always loud. Sometimes it's just a ramp, a signature, a front door that finally opens, and the knowledge that you stood your ground, not for fame, not for revenge, but for the right to live like everyone else. She leaned back in her seat as the van pulled away. She didn't text anyone, she didn't post online. She just sat there, watching the city go by, feeling something she hadn't felt in a long time: peace. She'd fought. She'd been doubted. She'd been mocked, but she'd stayed true. And in the end, the truth was enough. Not because the system was perfect, but because she refused to let it silence her. And somewhere, in another apartment in another city, someone else might hear her story and think, maybe I can fight too. That was the real victory. Not just for her, but for everyone who'd ever been told their needs were too much trouble, because they weren't. They never were. 2 weeks later, she sat at her front door and watched as 2 workers carried the last piece of the new ramp into place. It was a simple structure, smooth, gently sloped with handrails on both sides and bright yellow edging for visibility. It met every ADA standard, just like the court order said. And it was real, solid, permanent. She hadn't believed it would happen until the first screw went into the concrete. The landlord hadn't shown up. He'd sent a contractor with a copy of the signed agreement and a mumbled apology. She didn't need him there. She didn't need his words. She just needed the ramp. When it was done, the foreman wiped his hands on his jeans and nodded at her. All set. You can test it if you want. She rolled forward slowly, her tires meeting the smooth surface for the first time. No bumps, no wobble. Just a steady, gentle incline leading straight to her front door, the door she'd stared at, from the sidewalk for over a year, wondering if she'd ever use it like everyone else. She went up, then back down, then up again. Each time, a little part of her that had been coiled tight for so long began to relax. Neighbors came out to watch. Some clapped, others just smiled. One elderly woman brought her a cup of tea and said, "About time they did right by you." She thanked her, sipped the tea, and stayed outside longer than she had in months. Just sitting there in the sun, on her own property, through her own front entrance. It felt like freedom, even though she'd never technically been locked in. But the real surprise came a few days after that. A local news station reached out. They'd heard about her case through a courthouse clerk who'd been moved by how she'd handled herself. At first, she said no. She didn't want attention. She didn't want to be a poster person for anything. But then she thought about the woman with the cane, the one who'd thanked her in the hallway, the one who was fighting for her grandson. Maybe her story could help someone else. So she agreed to a short interview, not in a studio, not with dramatic music. Just on her new ramp, with her cat peeking out the window behind her. The reporter asked simple questions. What kept you going? Were you scared? What? Do you hope others learn from this? She typed her answers slowly, her device speaking in that calm, even tone she'd grown used to. I wasn't brave, she said. I was just tired of being treated like my needs didn't matter. And I hope people learn that you don't need a lawyer to have rights. You just need proof, patience, and the will to keep showing up. The story aired on a Tuesday evening. By Wednesday morning, her inbox was full. Messages came from people all over the state, some in wheelchairs, some with chronic illnesses, some caring for disabled family members. They wrote about landlords who ignored requests, schools that denied accommodations, stores with out-of-order elevators for months. Many said they'd given up, but after seeing her, they decided to try again. One message stood out. It was from a teenager who used a power chair and lived in a small town. I've been asking my apartment manager for a ramp for 6 months, they wrote. They keep saying next month. I was about to move out and live with my aunt, but now I'm printing your court documents. I'm going to file my own case." She cried when she read that. Not sad tears, the kind that come when you realize your pain wasn't wasted, that it might actually help someone else avoid the same struggle. Then something even bigger happened. A local nonprofit that supported disability rights contacted her. They'd been trying to launch a program to help people represent themselves in housing and accessibility cases, but they lacked real-world examples. Would she be willing to share her experience? Maybe help design a guide, simple, clear, with step-by-step instructions and templates for letters, evidence logs, and court forms? She said yes. Over the next few months, she worked with them every Sunday afternoon. She reviewed legal language and rewrote it in plain English. She recorded short videos showing how to organize evidence, how to speak clearly using a communication device in court, how to stay calm when people doubt you. She even helped create a checklist. What to do when your landlord says no. They called the project Doorway Justice. It launched online for free with no sign-up, no paywall. Within weeks, over 1,000 people had downloaded it. She never expected any of this. She just wanted a ramp. But life has a way of turning small acts of courage into something much larger. Back at home, things kept changing, quietly, steadily. She landed a new design contract with a company that valued accessibility from day one. They even asked her to consult on their website's usability for people with disabilities. For the first time in years, she felt seen not despite her disability, but because of the perspective it gave her. She also started leaving the house more. Not because she had to, but because she wanted to. She went to the library. She met a friend for coffee. She even attended a city council meeting about sidewalk repairs, something she'd always wanted to do but couldn't before. And every time she rolled down her new ramp, she felt a quiet kind of pride, not in winning but in refusing to disappear. One afternoon, as she was watering the small pot of marigolds she'd placed by her door, a gift from the neighbor who brought tea, the courthouse judge walked up her driveway. She recognized him immediately. He wore plain clothes, jeans and a button-down shirt, and carried a folder. "I hope I'm not intruding," he said, stopping at the bottom of the ramp. She shook her head. Her device said, "You're welcome here." He smiled. "I came to see it for myself. The ramp, the resolution." He looked around. "It's good to see it actually happened." They sat on the small bench she'd added beside the door. He didn't talk about the case at first. He asked about her work, her cat, how the neighborhood had been treating her. Then he said something she'd never forget. "You know," he began, "I've been a judge for 23 years. I've seen hundreds of self-represented litigants. Most are overwhelmed. Some are angry. A few are dishonest, but you reminded me why the law exists in the first place." She waited. "It's not about rules," he continued. "It's about fairness, about making sure the quiet voices aren't drowned out by the loud ones. That day in court, I almost missed it. I was tired. I had a full docket. I made assumptions. But you didn't let me get away with that. You held the line, with dignity, with facts, with grace." He handed her the folder. Inside was a letter on official courthouse letterhead, thanking her for her contribution to justice and offering to support the Doorway Justice Project with court-approved resources. "I can't change the whole system overnight," he said, "but I can make sure people like you aren't treated like an inconvenience the next time they roll through those doors." She didn't know what to say, so she just nodded and handed him a marigold. He took it, tucked it into his shirt pocket, and stood to leave. At the edge of the ramp, he turned. "You didn't just win a case, you know. You changed how we see things in that courtroom, and that matters more than any ruling." After he left, she sat there for a long time watching the sun dip behind the rooftops. She thought about all the days she'd spent stranded outside, soaked and frustrated, the nights she'd cried over missed opportunities, the moment in court when they'd all looked at her like she was wasting their time, and she realized none of that had been for nothing, because now someone else wouldn't have to go through it alone. A few weeks later, she got a photo in the mail. It was from the teenager who'd written her. In the picture, they were rolling down a brand new ramp outside their own apartment, grinning from ear to ear. On the back in messy handwriting it said, "Thank you for showing me I mattered." She pinned it to her bulletin board right next to her court order, not as a trophy, but as a reminder. Justice isn't always dramatic. It doesn't always come with fanfare or headlines. Sometimes it's as simple as a ramp, a letter, a shared guide, a judge who listens, a teenager who finally gets to come home through the front door. And sometimes it starts with one person, tired, underestimated, and told they're asking for too much, saying, "No, this is fair, and I won't stop until it's mine." She rolled back inside that evening, closed the door behind her, and made herself dinner. Just an ordinary night. Quiet, peaceful, hers. But as she ate, she smiled. Because for the first time in a long time, ordinary felt like enough. And maybe, just maybe, that was the real victory.